My name is Carolyn Cooper. I'm a research professor at the School of Public Affairs at American University, which has been conducting the Criminal Courts Technical Assistance Project under Bureau of Justice Assistance sponsorship for a number of years. The purpose of this project has been to assist courts in improving the administration of justice, particularly regarding criminal cases. The project has given particular priority to assisting courts in developing the judicial leadership and oversight necessary to ensure that the criminal case flow process proceeds efficiently and timely and in a manner that guarantees the rights of the Constitution and state statutes to all involved and promotes public confidence in the criminal case process. The DVD modules that we have prepared are designed to be used by judges, court administrators, clerks, judicial educators, and others interested in instituting criminal case flow management improvement programs. Recognizing that every court operates a little differently, reflecting its own local legal culture, these DVD resources have been designed to apply the general case flow management principles and national standards that apply to all courts. The DVD resources we have developed fall into three basic categories: an overview of the purposes of courts and principles of case flow management provided by Ernest Friesen and Maureen Solomon, a discussion of how to institute a criminal case flow management program, and third, application of criminal case flow management principles directly in the courtroom, to a first appearance, to a request for a continuance, to an initial scheduling conference.
Courts serve many purposes in our society, of which we're all aware. But the one that we are most concerned with in the discussion today is the just, fair, and timely disposition of cases. And for that reason, I don't think it's an oversight to say that case flow management is the heart of court management. And having said that, I believe it's important to define what we're talking about when we say case flow management. And this is a definition that has been in use and generally accepted for a number of years. And it is as follows. Case flow management is the coordination of events and times necessary to move a case from initiation or filing to disposition, regardless of the type of disposition. And it's important to focus on the idea, regardless of the type of disposition, because we tend to focus often on trials. And the fact is, as we all know, that probably 95 to 97% of dispositions will not be by trial, but will be equally fair and just, but they will be by settlement or negotiated disposition in a criminal case. It's also important to notice in this definition that we talk about management of case events, and we talk about managing the time. And we don't say, the definition doesn't say how much time is the right amount of time. And in fact, if you look at the American Bar Association Standard Point 2.5, you'll see that it says the following: any time not reasonably required for the pleadings, discovery, or disposition of the case is unacceptable and should be eliminated. So it's essentially saying that as we manage our case flow process and as we manage the time between events, it's important to determine how much time is actually required in this case for a fair and just disposition. And we want to assure that the case gets that amount of time and not more. It gets all the time it needs. Now, time is a very important element because you have to clearly allow enough time to complete the event. Lawyers need enough time to prepare and be ready for the disposition. But the time can't be so long that they forget about the case. And so we have to, the imminence of the next event is a very important factor. So we want to allow enough time to prepare, but we want the time to be short enough to encourage that preparation, to be able to make an evaluation of the case and dispose of it at the earliest possible time. Then we reserve our resources for those cases that are more complicated and will require a trial for disposition. lawyers tell us that when the time interval between event 1 and event 2, event A and event B is too long, the case winds up in the bottom drawer of their desk, and they only pull it out when they get a notice from the court that it's time for the next appearance. So I would say that an important question we need to ask ourselves, and you may have asked yourself this question already, if only 2 to 5% of cases will require a trial for disposition, why does it take so long in many of our courts to achieve disposition, the non-trial disposition, in the 95 to 98% that will not require a trial? And that in turn leads us to think about what kind of management can be imposed by the court to attempt to achieve that earlier disposition. And that really, if you think about it from a statistical standpoint, it's kind of interesting because we try to meet time standards for disposition, and if you could dispose of the cases that won't require a trial in a more timely fashion, achieving the disposition time standards is really a no-brainer. You'll do it statistically because you only have that small percentage of cases left that will take more time and require a trial. So as we talk a little bit about the essential elements of effective case flow management, we'll talk more about managing time, we'll talk more about early intervention of the court, and we'll talk about making a realistic determination about how much time is required in each case depending on the facts and circumstances and characteristics of the case to achieve that fair, timely, and economical justice that is our goal. The fundamental premise underlying everything that I've said so far really is that it is the responsibility of the court to supervise the progress of each case. The court has that responsibility, the judges have that responsibility, and it's a big responsibility, and sometimes it's a little daunting to think about, but the supervision by the court is very basic and appeared many years ago in the ABA standards, and they're very clear about that. They say the court and not the lawyers should control the pace of litigation. What was the situation that you found when you became presiding judge in Flagstaff?
Well, the situation on the ground was that I was in a locked war with my funding authority, our Board of Supervisors, and they basically said, we're not going to give you any more money to replicate what you're already doing. We were all working very, very hard, and it was very difficult because we knew we weren't getting ahead. We knew we weren't even keeping up. But we sort of justified it like a lot of people do, and we just said we're working as hard as we can work. We were working very hard, but we were not very efficient. And we didn't know it. We didn't realize where our inefficiencies were, and that was part of the problem. I'm fond of saying I don't know all the answers. Heck, I don't even know all the questions. I didn't know what the problems were. And my court administrator came to me and said, we need to bring somebody from the outside in, and there's this new thing called case flow management. This was 1994. I hadn't heard of it at that time. And I remember I put my head in my hands and I shook my head and I said, Gary, I can't work any harder. There's no more hours. And he said something that's rather trite, but still very true. Let's work smarter, let's not work harder. And the thought, I think that was kind of the epiphany for me, maybe there is a better way to do things than the way we're doing it. And that's when we decided to retain the consultant who then came in and helped us.
And how did the consultant work with the court?
I become an absolute convert to this system, bringing somebody in from the outside, because the consultant gave us a perspective that we couldn't see. And this consultant started asking one basic question at every stage in the process: why? Why do you do this? We just thought, well, this is the way it's always done, so we never challenged ourselves. The consultant also brought a sense that we could change the system. And something that I have found in other courts is really a hard notion to wrap your head around sometimes by presiding judges and court administrators is you really can change the system. It's not set in stone. And the consultant helped us very, very much with that. The consultant also brought an expectation that there was going to be change. We went through a lot of meetings with the consultant, and then everybody started whispering, you know, change is coming, change is coming. The consultant came back some months later. We knew the consultant was coming back later, and it gave us sort of the gas in our tank to keep moving on it, because we didn't want the consultant coming back 6 months or a year later saying, well, you haven't made any progress. So it really kind of pushed us along a bit.
What we know from the research we've done over the years and from working with courts throughout the country is that judicial leadership, starting at the top with the presiding or chief judge, is extraordinarily important. In fact, it's of prime importance to being able to implement an effective case flow management system. Leadership of the chief or presiding judge really sets the tone throughout the system. And it's important for several reasons. First of all, it conveys to the organization, to the judges and the staff, the court's intention with respect to managing the progress of cases. Secondly, it conveys to the lawyers the court's expectations for proceeding in a timely fashion. Third, it conveys to the public what the goals of this court are and what the court intends to do to assure that delay does not become a problem. And a body of knowledge has been developed and tested and retested and validated about what it takes to achieve an effective case flow management system that achieves the goals of timely, just, and fair disposition. One of the things we absolutely know is that the role of the judge is pivotal in setting expectations, in creating an effective system, and in conveying what is expected of everybody in the system, all the judges, the lawyers, the litigants. It's now generally accepted in the criminal justice community that effective case flow management is characterized by court supervision of the time and events, as I said earlier. Effective case flow management incorporates early judicial case management to achieve earlier dispositions in the great majority of cases that will be disposed of without a trial, and this is very important, to create a predictable process that the lawyers and litigants can depend on, so that an appropriate timetable is developed in every single case. Focus on the word predictable, because that's one of the things historically that has been missing from the process in courts, is a predictability. What you're trying to do is to create what others have called the expectation of timeliness. And the definition of a meaningful event, of course, is an event that either disposes of the case or makes significant progress toward disposition. So that when we create the expectation of timeliness, it means we in the court have a plan for our, let's say, for our criminal case management system. And we have defined the meaningful events. We know what kind of events need to occur to move the case toward disposition at a reasonable pace. And it means that we have defined the amount of time that is reasonable between each one of these events, so that lawyers know this is the way this court operates. And we want lawyers and litigants and judges and staff to expect a timely process and a timely outcome. If the court's philosophies and practices are not rigorous and consistent, a lawyer's preparation efforts may not be completed in the optimal time frame. Cases will drift, and dispositions will take longer than actually required. And we're talking about early and continuous judicial supervision of the progress of cases. So we know that early judicial intervention of a management nature is really the gold standard for getting a case on track early and making sure that we achieve a timely disposition. And often this occurs in the form of an early case management conference between the judge and the lawyers in the case. And it is the time when the judge, in consultation with the lawyers, defines the meaningful events that will apply in each particular case. And it's the time when the judge, again, in consultation with the lawyers, reaches agreement on the time that should intervene between these meaningful events, and generally gets agreement on approximately what the timetable will be for disposing of the case. How complex is the case? What are the characteristics of the case? What are the problems potentially that the lawyers will potentially face in trying to dispose of the case? What we find out when we interview lawyers is the following, especially in criminal cases. You ask the question, how early do you have a pretty good idea what the disposition should be in this case and how long it should take? And lawyers generally answer fairly candidly and say, you know, within a couple of weeks, as long as we have a timely police report, within a couple of weeks, we have a pretty good idea of what the outcome should be. So again, you go back to the question, well then why does it take so long to achieve a disposition? With the judge in a management role, winds up focusing everybody's attention on what will it take to dispose of the case. And we know, interestingly, that lawyers very early have a pretty good idea what it's going to take in most cases. Again, remember that 95 to 98% of cases will not require a trial for disposition, and a very high percentage of cases could be considered less complex or might even be called simple in terms of what's required for disposition. You take advantage of what the lawyers know already about the case and focus on what it's going to take to dispose of the case.
We're going to be looking at the criminal justice system along a continuum of events and look at the case management concepts that you have and will be hearing about. The logical place to start is with the first appearance. The first appearance may be in the limited jurisdiction court. Some places you go directly into the general jurisdiction. It will vary based upon your state, your county, your circuit. For the purposes of what you're about to see, we are assuming that this is in the limited jurisdiction court. We know that oftentimes this is a perfunctory event, that the main goal is just to get the person into the system. As this event unfolds, take a look at it and see what actually is occurring, what can occur. We know we're going to be looking at release decisions. Who should be there besides the judge? Is this an appropriate time for the prosecutor to be there? Defense counsel? Is there information being provided that the court can make the decision upon release, that the court can then set the next events? So now let's go and take a look at the very first appearance before the court.
Next is number F5678, People v. Smith.
Ms. Smith, you've been charged with 3 counts of receiving stolen property. You have a right to be represented by an attorney. Do you have an attorney?
No, sir.
Ms. Russell, will you serve as stand-in counsel for the purpose of this hearing?
Yes, Your Honor, I'd be happy to.
Okay, I have a report from pretrial that recommends that the defendant be released on personal recognizance. Does the state have a position?
We have no position concerning the release status, Your Honor. We have talked about the potential for a resolution of the case. I've talked to the police officers. I've also talked to the victims in this matter. We might be able to come to a resolution, although that's not certain at this point. It may obviate the need for a release hearing, but right now we still have some work to do. Thank you.
Your Honor, Ms. Smith, if you'll step up to the podium, ma'am. Well, Your Honor, Mr. Coker has provided us with some preliminary information, but based on my review of the report, it suggests that there might be some other matters. At this point, we would ask for a continuance so that we could review that information that's been provided. I would not be in a position to talk to Ms. Smith at this point about a plea bargain. I would, however, like to support the recommendation from pretrial. Ms. Smith has strong ties to this community and she has no significant prior history. So we would specifically ask that the court follow the recommendation from pretrial services that she be released at this time.
Okay, I'm going to follow that recommendation and you'll be released on your own recognizance and we'll set this case over for a second call.
Thank you, Your Honor.
going to see the first appearance before the General Jurisdiction Court. Once again, let's take a look and see what is occurring here so that you can look at your jurisdiction, how you do business, and pick up some of these points that the judge is going over. First of all, the judge is going to confirm counsel, to have the counsel that's going to represent the defendant before the court. We're going to be taking a look at and see where are we with discovery? What is the status of discovery? Have the charges been brought? And what are the special needs that are required at this point in the case? In some courts, we know that they do have guidelines that set forth events and time frames. Does your court have guidelines? Let's see if this court has guidelines setting forth the various events, the time frames, and what the judge does to assume this early control and exert continual control over the case as it proceeds.
Next case is F5678, People versus Smith. Indictment returned 1 week ago, 4 counts receiving stolen property.
Thank you all for being present this morning. Mr. Sonner, as a representative of the state, have you provided disclosure and discovery to the defense in this matter?
Yes, Your Honor. We furnished the full packet of discovery, everything in our file, to the defendant 2 days after the indictment. And our witnesses have been notified. They're ready to go to trial. And we have made a plea offer to the defendant.
All right, thank you. Counsel, is that correct?
Well, Your Honor, it is in fact correct that we received some information 2 days after the first appearance. However, as I indicated at that time, there appeared to be some additional matters. This case arose pursuant to a warrant, and so we anticipate that there will be some motions that will have to be filed, specifically a motion to suppress. And it's also my understanding through my investigator that there may be some additional materials that the prosecutor may not have that's in the police department's files, and we would need those matters to be able to proceed. And finally, based upon that additional information, I've had some discussions with the district attorney's office, and it's my understanding that they may be revising the plea offer.
All right. Counsel, these motions that you mentioned that you might be filing, when will you be filing those motions?
Your Honor, I have a number of trials scheduled over the next few weeks. I would anticipate I would need at least 2 to 3 weeks to get that done.
All right. Counsel, is there anybody in your office that can start working on these motions so that we make sure that we can meet that time schedule? I just don't want to have 2 or 3 weeks and then you come in and say, I've been in trial and so I haven't had a chance to work on the motions.
Your Honor, I understand. We have a summer intern, but frankly, they are really overloaded. I will do my level best, and I'll ask whomever I can to try to help out. But realistically, 2 or 3 weeks is about the best I can do, Judge.
All right. Well, Counsel, I certainly want to get your input, but you know my preference. I don't want to have hearings that don't accomplish anything, so I'm going to go ahead and set this for a hearing on motions in 3 weeks so that we can get that done, and that'll give you a little bit of extra time to get that motion filed and then the state to file its response to that motion. Is that fair?
Thank you, Your Honor. Yes, sir.
Thank you. Mr. Sonner, I forgot to ask you, have you been in consultation with the victim in this matter? Has the victim been apprised pursuant to the victim's rights?
Well, the police have been in contact with the victim, but we will be in contact with the victim before the hearing date.
All right. Thank you. Will the defense be prepared to respond to the plea after the resolution of those motions, Counsel?
Your Honor, I would think so. Obviously, my client would need some time to speak with her family, but other than that, we would be ready to proceed.
All right. Counsel, I would just remind both of you that the court does have a settlement conference process, that if at any time you think you're ready, and again, I emphasize that you're ready, that you have all of your ducks lined up, that you're ready to go ahead and do a settlement conference. If you just please notify the court, then we'll get that process started. Thank you very much.
Thank you, Your Honor.
The next event you're about to see, we'll call it an interim Caseflow management conference. At this time, you're going to be seeing the judge, counsel, and the defendant determining what are the next appropriate steps. At this point in time, what occurs will be driven by the complexity of the case and the seriousness of the charges. You may find in a less serious case at this point in time, you are ready to talk about plea, maybe even take a plea. We're going to assume that the case is a little more complex than that. And you will see the judge, counsel examining, what really are the issues, what needs to be done to move this case along. And so they're going to be talking about any issues that remain, that whether it's extended discovery. You will see a discussion here about when to set that next date, which once again is going to be driven by the complexity of the case and the issues that may arise. So, and then what is going to occur at that next date. And this is also a good time for the court to initiate kind of, where are you with this case? Is this case going to be going to a plea? So you may see the court, or maybe you yourself, during these types of conferences, also just ask counsel, where are you with your discussion? Is there something the court can do to move it along? So let's look and see what type of issues the court addresses, what kind of solutions the court puts forth to keep this case moving along.
Next case called is F5678, People versus Smith. This case comes on for case management conference.
Mr. Prosecutor, what's the status of the case, please?
Well, Your Honor, at this point, we've been unable to reach an agreement for settlement. We have made an offer to the defendant of 6.5 years in the state prison, and so far the defendant has refused that offer.
Counsel, is that what the defense understands the offer to be?
That's correct, Your Honor.
Okay, thank you. And you've discussed that with your client?
Yes, Your Honor, I have.
All right. Ms. Smith, have you talked to your attorney about this plea offer that's been offered by the state?
Yes, Your Honor.
Okay, and you understand that plea offer?
Yes, Your Honor.
And you understand the penalties you face if you go to trial. You're going to be facing a mandatory prison term. Do you understand that?
Yes, sir.
Okay, thank you. Counsel, Mr. Sonner, has all of the discovery and disclosure been provided by the state to the defense?
Yes, Your Honor, we've provided everything except the 911 tape, which is in the possession of the police department. We don't have possession of that report.
Why haven't you provided that to the defense?
Well, we've asked for the police for it, and they so far haven't given it to us.
How about the witness statements, counsel? Have you got those and provided them to the defense counsel?
Yes, all of those have been prepared and have been provided.
Ms. Russell, can the defense obtain that tape from the defense directly? I have not been faced with this problem before.
Well, Your Honor, generally what the police departments say to defense attorneys is that it is their practice to provide items to the prosecutors so that they can review them before we receive them in case there's any material that we would not be entitled to. If, however, the court directs me to attempt to obtain it, I'll certainly do so. There was also a police report that was referenced in one of the initial reports, and that doesn't appear to be in the discovery, Your Honor.
Okay. Mr. Sonner, do you know anything about that police
No, I
report?
don't know anything about that, Your Honor. We have given her everything that we have in our file, but I will look into it.
Okay, I'll give you a week to do that. Let's get some time limits here. So can you do that within the week?
I certainly can.
Thank you. As far as the 911 tape is concerned, I am going to issue an order because, counsel, I understand your difficulty in sometimes dealing with the police department, getting them to cooperate. They think that they need to get the permission from the prosecutor. I'm going to go ahead and issue an order that they provide you with that 911 tape so that you can get moving on your case. Do you anticipate you're going to need to be filing any other motions?
Well, yes, Your Honor. Based on the 911 tape and what we anticipate its contents may be, I would anticipate filing a motion to suppress, but I would need some time to do that once I actually have the tape in hand.
Okay. What kind of time frame are you looking at, counsel?
Your Honor, I would request 3 weeks.
Okay. Well, let's see. You're going to need probably a week to get that tape. Okay. I think that's a reasonable amount of time. We'll go ahead and go with that. Mr. Sonner, do you have any, do you anticipate the state filing any prosecutor's motions?
Yes, Your Honor. We plan to file a motion to be able to use similar acts at the trial of the state's case in chief, and we will file that directly.
All right. Council, if I go ahead and set a motion hearing in 3 weeks, will that give everybody time to get your motions filed, get the responses filed, or we need a little more time than that? I just need to get your input. I don't want to set a hearing that we don't get things done.
Well, Your Honor, I would have time to file, but because they're evidentiary motions, the prosecutor would have to get the witnesses here.
Counsel?
Well, Your Honor, I'm not so sure we can get the witnesses here within 1 week. We'll do our best, but I'm not sure we can.
Well, I'm going to go ahead and set this out, given the response and reply time. I'm going to set this out for 4 weeks. Now, this is a certain date. I want you to get your motions filed and anticipate that the other side is going to have response and reply time. So get your motions filed within the time limits so that they can get their response and reply time completed before that hearing date. It gives you plenty of time to notify your witnesses. It gives you plenty of time to get done what you need to get done, but I don't want you walking in the courtroom handing the other side your reply. I want to have that stuff done. I don't want anybody coming in here saying, I haven't had time to review what the state has said or the defense has said in their motion. Get it done well before that time. I'm giving you this extra time so that we can make sure we get it done. Okay, do we have any other issues that we need to address as far as disclosure or discovery? Counsel?
The state doesn't, Your Honor.
Your Honor, there was a matter of the trial setting. The concern that the defense would have is, assuming we hear the motions on the date that you've indicated, that we wouldn't have time to get a trial transcript, a jury motions transcript back.
Counsel, this court has a practice. We will not set a trial until we have all these pretrial motions resolved so that we know for sure the case is going to go to trial. My next question was going to be to you, do you think that a settlement conference might be appropriate in this case, such that the case might be resolved by non-trial resolution? Mr. Sonner?
That would be very helpful, Your Honor.
Counsel?
Your Honor, we'd certainly be willing to participate.
Okay. Well, then we get to the issue, is the state willing to participate in that settlement conference prior to the resolution of the pretrial motions?
Yes, Your Honor, we'd be willing to participate either before or after.
Well, Your Honor, we'd be willing to participate, but obviously my client would need all of the information in order to be able to make some final decision.
Okay, I would just simply ask that both of you be mindful of the court's calendar and that we can't schedule things on a dime. You need to give us a little bit of heads up that we need to have a hearing in a case, but this court will always be available to you to try and resolve any pretrial issues. By the same token, if you see that you're moving towards settlement and you'd like to strike while the iron is hot, all you need to do is pick up the phone and call my secretary. We'll set your case for a plea and we'll get the case resolved. I want to take every opportunity to resolve the case as quickly as possible. Are there any other issues that we need to talk about from the state's viewpoint?
No, Your Honor.
Defense?
No, Your Honor.
Okay, I want to thank you all very much and look forward to seeing you, and please be mindful of those dates we've set today. Thank you.
You will notice in these scenarios, there may come up an issue of wanting more time. You can call it a continuance or an effort to push off events. You yourself probably have experience, whether it's the initial appearance, the second conference, or even at the end where a plea was supposed to be taken. One of the areas that causes a lot of concern, because you as a judge want to be fair, is this request for a continuance. We're going to now go to a hearing that addresses that issue, even though it exists throughout these other scenarios that have been presented for you. It's important when you look at the continuance to see how do you view it? What can you as a judge do to determine what really is the issue there? What can be done to move towards resolution of that issue? But most important, this is part of the case flow management concepts of continuous supervision of the case, to anticipate when issues may arise and to try to come up with the best solutions that you can. There's always going to be a time when you're going to have to listen to counsel, accommodate the counsel, the parties, or other actors within the criminal justice system. You just want to be able to make the most appropriate decision. So let's see how this judge handles this request for continuance.
Next case is F5678, People versus Smith. Indictment was on 3 counts of possession and sale of controlled substance. At arraignment, parties were directed to complete discovery, submit motions by the end of the month. No motions have been submitted to the court.
Good morning.
Good morning.
The record will reflect that no motions have been submitted. A final plea date has in fact occurred, and Ms. Smith has elected to proceed. So at this point, I'd like to schedule this case for trial. On behalf of the prosecution, are you ready to proceed with the setting of trial date?
Well, yes, Your Honor, we're ready to proceed, but we do have some out-of-state witnesses that we have some difficulty contacting, and we haven't gotten a report back from the lab, which is not really within our control. It's the state lab, and as you know, they're often backed up and slow.
All right. And on behalf of the defense, are you ready to proceed with setting a trial date?
Good morning, Judge. We are not. Because we have not received those lab results and we have been unable to interview the witness that the state has been unable to find. It's a declared witness. It's one we desperately need to talk with. We can't proceed because we simply cannot get the information we need to decide whether this case is a case that should be tried or should be resolved by a non-trial resolution. Till we get that information, we're stuck.
All right. Thank you, counsel. Mr. Prosecutor, let's start with this out-of-state witness. How long have you known about this witness?
Excuse me?
How long have you known about this witness?
Oh, Your Honor, we've known about this. First, this isn't my case. I'm only the stand-in attorney. This is being handled by the Special Drug Unit. But nevertheless, we'll make every effort to try to get in touch with that witness, but at this time, I can't tell you that.
Well, let's start with, it is the state's case. Now, if the state has elected to send you, then you are the person who needs to respond to me. If you need to get someone else, I'll give you a recess to go make a phone call and get them here, because we can't proceed unless we have good information. Do you need to call somebody, or are you prepared to talk to me about these matters?
Well, Your Honor, do the best I can. The attorney who's to try that case is now in another courtroom and is unable to be here.
Yes, sir, and if he quits tomorrow, can I make him come try the state's case?
I don't know about that, Your Honor.
Well, then it is not his case, it's the state's case. Now, do you want to call him, or do you want him to live with what you tell me?
Your Honor, I can call him, but I don't think that will resolve the issue.
Yes, sir. Then I'll give you 5 minutes to call him. We'll be in recess. You may be seated.
Court returns to session, reconvenes on F5678, People versus Smith.
Your Honor, I have spoken to the attorney who's to try this case, and after consulting with him, we're prepared to proceed without that witness and will waive the use of that witness at the trial.
All right. Thank you, counsel. That resolves one matter. Now let's talk about this lab report. Has the prosecution, in fact, requested the lab results?
Oh, yes, Your Honor. We requested the lab report at the time we sent it, and we've had contact with them by phone, but they have it on an expedited calendar, but we still don't have that report.
Yes, sir. And did they tell you when you were likely to have it?
No, they did not, Your Honor. They never do.
And is there any other means of getting those results? Can you send it to a private lab?
No, Your Honor. I do not have any facility or any budget to be able to send it to a private lab. I will call them again and tell them that the court is concerned to see if I can have it moved to the front of the line and get it in time for defense counsel.
Yes, sir. And if I schedule a case for trial, does that move it to the top of the list?
Yes.
All right. Then as soon as I put it at the top of the list because I scheduled a trial date, that should take care of that issue.
Well, I did something that I can tell the lab and they will react to it. Again, they don't work for me. They work for the state.
But you do have the subpoena power if I schedule a trial date,
yes,
correct?
Yes, you do. Yes, we do.
So if I schedule a trial date, you'll subpoena them, right?
Well, we've already subpoenaed them, but
yes,
we don't have them subpoenaed for the trial date.
Yes, sir.
We already notified them.
Yes, sir. And if I set a hearing date that requires their presence, if you don't have a result, they will appear if they're under subpoena, will they not?
We'll be in trouble.
Yes, sir. Got it. Thank you. Now, counsel.
Yes, Your Honor.
I understand you don't have a lab report, but you do know they're drugs, don't you?
Your Honor, I just would feel uncomfortable making any comment at this point.
Yes, sir. Do you have any reason to believe they're not drugs?
If the prosecution would make probation available, Your Honor, I think we could probably resolve this case.
Yes, sir. So if we reach a point where there's some resolution, that lab report would be significantly less necessary. Is that right?
Absolutely.
Yes,
absolutely.
Sir. Now, is the weight of the drugs an issue or merely what the substance is?
No, it's below the threshold, but because of my client's priors, Your Honor, we're looking at a mandatory sentencing, so the weight is not as important as the substance of it.
All right. And is it not the case that there was a field test that was done with respect to those materials?
I have read that in the police report, yes, Your Honor.
So for purposes of a trial, the only thing you need to know is whether or not it is in fact what the preliminary tests say it is.
That would be a fair statement, yes, Your Honor.
So that would be one question at trial, would it not?
It would.
And if it turns out that it's not, you don't have an issue, isn't that right?
That's correct.
All right. So for your purposes, since weight is not an issue, the actual result is not an impediment to trial, now is it?
Well, just other than confirming it is an illegal drug, because of the mandatory sentencing, and as you can understand, it's very, very significant to my client with mandatory sentencing that issue be resolved, or it's going to come back on an appellate issue that ineffective assistance of counsel that I didn't make sure that it was in fact drugs.
Well, no, sir, because if it's not drugs, when we get to the trial, we won't be having one, now will we?
Exactly.
So you win.
I agree.
All right. So then
Thank
that
you.
would not be an impediment to you preparing for trial if you assume the worst.
Not for preparing for trial, that's correct.
All right.
Thank
So
you.
at this point, we don't have an issue with out-of-state witnesses or lab reports that would preclude scheduling a trial date on this matter. Is there anything else we need to take up on behalf of the prosecution?
No, Your Honor, we're prepared to go to trial, and we feel strongly about this case, and we will be prepared at the time of trial.
Thank you. Are there any other matters we need to take up on behalf of the defense?
Your Honor, the only
Including
thing that
setting a
is,
trial date.
the only thing that is of concern is that my schedule is absolutely packed. I'm in trial for the next 3 months. I'm a sole practitioner. I work for the county as a contract attorney on conflict cases, and there's no more days left for the next 3 months for me to try this case.
Yes, sir. You said that you have trials scheduled, but you won't know whether you're in fact having a trial until something goes forward, isn't that right?
That is correct.
And you're aware that in this jurisdiction, approximately 98% of all criminal matters, in fact, resolve prior to trial, are you not?
I am very aware of that fact.
All right. So at this point, if I schedule a trial date and you're busy, we'll have to reschedule it. But
That's
the
correct.
odds are you won't be busy.
That's correct.
All right. So then that would not be an impediment to scheduling the trial date.
That's correct. The only thing that I would ask, I know that the trial that I've got set, the next 2 trial dates are next door to your courtroom with Judge Jones. Those cases, we've gone past the plea deadlines. Those 2 cases are going to go. I'm anticipating those 2 cases, if I remember right. Let me check my BlackBerry, but I think those 2 cases are set to go. Yeah, they're set to go. The first one is 10 days and the second one is 8 days. So those 2 I know are going to go to trial. Then we start getting into the fuzzy area that you're talking about.
All right. Well, with respect to those 2 matters, I'll confirm with Judge Jones regarding the likelihood of them going, and if your estimate is in fact correct, we'll set a date that's beyond those 2, which would be about 3 weeks out, would it not?
I think so, yes.
All right. Anything else we need to take up?
Not other than that we do have 1 expert witness, but I believe that we'll be able to get that expert witness on board and ready to go in approximately 3 weeks. I think that that's fine. We can get the report done and exchange it with the prosecution within that time frame.
All right. Thank you both very much.
Thank you.
Thank you,
We'll be
Your
in
Honor.
recess.
We're going to call this next event the final pretrial conference. This is where the case is coming on for sort of a final review. What's going to be decided here will set the direction that this case is going to take. Is it going to go towards a plea? You will see the judge determining really what is our status here, what needs to be done. I know some of you may have some issues with this concept of a plea cutoff, but you may see the plea cutoff date discussed to be reinforced. At this conference, the court wants them to realize that the day is, if this isn't it, it probably is the date that a decision needs to be made. You're going to see that if it's determined that this case is appropriate for a trial, that there's going to be a firm trial date set. You're going to see the judge examining with the counsel, make sure there are no other issues out there that need to be taken care of. If there are, set dates by which motions may be filed that, or whatever the issue might be, is put forth to be resolved. Adopt intermediate steps to make sure that you don't have to address an issue of continuance down the road. But basically, you're going to be setting the tone to make sure this case is going to be prepared to proceed to trial.
Next case is F5678, People v. Smith, final plea conference.
This matter is before the court for a final plea hearing. The record will reflect that counsel for the state is present, counsel for the defense is present, and the defendant is in fact present. Mr. Prosecutor, was a plea offer made to Ms. Smith?
Yes, Your Honor, we have evaluated this case and we have made an offer, and it is going to be our final offer.
All right. And counsel for the defense, was a plea offer in fact conveyed?
Yes, Your Honor, it was explained in full detail. I have to bring another matter to the attention of the court. My client has advised me when I came in this morning and met with her that she wants to terminate my services. She's not happy with what I've been telling her, and she just wants to terminate my services, and I need to advise the court so that, because I know the court has some queries that it will need to make to the defendant.
Ms. Smith, is that in fact the case?
Yes, Your Honor.
Okay, can you tell me why it is you want to fire Mr. Coker?
I just don't like what he's telling me.
Yes, ma'am. Now, the thing about what it is that lawyers do for you, it is not their job necessarily to tell you what you want to hear. It is their job to give you their best advice and to give you the benefit of their legal expertise. Now, what is it that he told you that you don't like?
What the possibilities are.
Well, ma'am, that's his job. His job is to tell you the truth, and that is what the possibilities are. In this state, the charges that you are facing are charges which have a mandatory minimum sentence based upon your history. And so it's his job to make you aware of that fact. Now, what you decide to do, of course, is entirely up to you. So if what he told you was that these charges, based upon the circumstances of this case, carry a minimum mandatory sentence, he in fact advised you accurately. The purpose of today is to determine whether you wish to try to resolve this matter on a negotiated basis or whether you want to go forward and have a trial. So at this point, are you prepared to tell me what you want to do? Or would you like to talk to Mr.
May I have a
Coker?
moment, Judge, talk
Sir.
to my client? Your Honor, I think the thing that's disturbing my client is that we went to a lot of effort to have an evaluation done on her, and through no fault of hers and through no fault of my own, that evaluation has been very slow coming. We think it will make a big impact with the state when they see that evaluation, as it deals with some of the pressure she was under, the substance abuse problems that she's had in the past, but most importantly, Your Honor, we think it goes to the fact that she's really taken the steps since this all took place to try to address those issues. She's not just been a stump sitting in the forest, she's really been taking control of her life and trying to fix what's been going on. And she's frustrated that she's made that big effort, and the state's not even considering that in their offer. And while I understand her frustration, I can't go to the doctor and the folks that did her evaluation and make them give that report to us. We anticipate that report should be to us any day. I mean, within the week, we hope. And then once that report is submitted to the state, that maybe that will have an effect on the offer. We understand with the defendant's priors that she's looking at mandatory sentencing. She's frustrated with me because I can't make this report happen, and because the plea offer hasn't gotten any better in spite of all the efforts that she's made on her behalf. So I guess what I would ask on her behalf is if we could postpone this for 1 week to allow us to get that report. Mr. Sonner and I then can sit down with that report and see if there's any way, any headway that can be made. I know that the court is reluctant to do that, but it's one of those unique circumstances where we have a housewife who's been taking care of her kids, she has family, she has very strong family support, she's done the things that are necessary to try to get her life under control, and to me, it's just a waste of resources to send her to prison simply because of mandatory sentencing. And I think that I'm hopeful that Mr. Sonner and I can come to an agreement. Once we have this report, it will give him perhaps the substance that he then can go to his superiors and get a variation on their internal office guidelines on what would normally be a mandatory prison term.
All right. The report that you're referring to, it doesn't have anything to do with any issues of competency, correct?
No, not at all.
Well, now, insofar as it is a matter that would be for purposes of mitigation, you and the defendant have known that this hearing was scheduled for some period of time. Is there some reason you didn't take care of this sooner?
Your Honor, as soon as I got appointed and we had the first opportunity to sit down and talk, I went immediately out when I found out all of the efforts that she has made, because this is somewhat unique with some of my clients. I don't normally see my clients taking the initiative here. I immediately contacted the experts, but unfortunately the experts are some distance away. She's in custody. We had to make those arrangements to get the expert to the jail to do the evaluation. And ultimately what we had to do is I got, as you may know if you review the file, we got a temporary furlough to get her out, and I took her personally to the counselor's office that did the evaluation. So we've been working very, very hard, but as you know, with mandatory sentencing, these kinds of issues have become so important that the people that are out there that are willing to do them have been narrowed down, and boy, they're just very, very busy.
Now, Mr. Coker, we had several case management conferences in this matter, and this is the first time I'm hearing about this. Can you tell me why that is?
We thought that we would have the report already. We really did. I didn't imagine that it would take 45 days after the last interview for that professional, that expert, to give me that report. Why it's taken so long, I cannot. I have made phone calls, I have emailed, I've done everything I can to try to move it along. I'm on kind of that horns of that dilemma. I don't want to irritate the person that I'm asking to give a favorable report for my client, but on the other hand, I've tried to convey the urgency that I know this court expects. I've been practicing in front of you for years, and I hopefully have some reputation that I don't come in here and try to con you. I really have been sincerely trying to get this report.
Yes, sir. Now, when we had that case management hearing, and I asked you at that point whether there were any other matters outstanding, and you indicated that there were none, which is how we got to this date, you didn't say anything about this report. So, let me ask you this. Have you discussed what you anticipate its findings to be with counsel for the state prior to today?
In a vague sense, because candidly, I don't know what they're going to say. That this expert was, well, it's Mr. Frankel, and if you know Mr. Frankel, he kind of does his own thing, and I certainly wouldn't presume to put words in Mr. Frankel's mouth. I'm hopeful as to what it's going to say. My client seems to think it's going to be favorable, but I don't want to go to Mr. Sonner and say, Mr. Sonner, this is what that report says, and then have that report come out. That challenges my integrity, and I'm not willing to go there.
Yes,
I'm sorry.
You may have to sit.
Thank you.
Now, Mr. Sonner.
Your Honor, this is a very important case to us. This is a result of a long investigation. Our witnesses are ready to go to trial. What the defense is saying is that they have some mitigation testimony that they might be able to bring forth. And we know Dr. Frankel from times past. I can't imagine anything that's going to come in this report that's going to change the state's position with regard to sentencing or going forward. We're prepared to go, and we think that the court should hold the defendant's feet to the fire.
All right. Well, where we are then, Mr. Coker, does it sound like from what Mr. Sonner is telling me that this is going to make a difference in terms of his recommendation. So I'm not prepared to continue the matter, and I'm going to need a decision from you and your client. Do you need some time to talk to her today?
I will need to sit and talk with her. Judge, if I might just add, I don't like having cases coming back from the Court of Appeals. I don't appreciate the instruction I get from the Court of Appeals. I mean, I appreciate it on one sense, but I don't like doing things twice. And it just seems like a week invested now to get that report, even if it doesn't change Mr. Sonner's opinion of the case. And I think it will. I think we might be able to get a probation-eligible plea in this matter. That's huge. 6.5 years versus probation in this case is huge to my client. And I think it's one of the reasons she's lost faith in me is because she doesn't see any budging from the client, from the prosecutor. I understand that the prosecutor's office has its formalities and its guidelines, and I understand that. I've busted my head up against those things many times, but I have been successful in the past in getting a modification. And I just, to me, it's time well spent that if we can keep, if you want to set a trial out, that's fine, but perhaps if you could just give us one more week to leave the plea opportunity open, then we might be able to save this matter coming back later on the ineffective assistance of counsel.
Are you done?
Yes, I am. Thank you.
Thank you, sir. Well, in the first place, the purpose of today is to determine whether or not a negotiated plea will be entered. I don't believe that whether or not a negotiated plea being entered does or does not happen will affect whether or not you are ineffective at the time that we schedule this matter for trial. Second, insofar as the state has indicated that its position is that this report is not likely to make a difference, it is my practice to accept what lawyers tell me. So at this point, where we are is you have represented to this court and to Mr. Saunier the best case scenario, assuming you get a report that is favorable, and Mr. Saunier's represented that it is not likely to make a difference. And so for that reason, I don't see a reason to reschedule this matter today. Now, when we get to trial, if Ms. Smith is convicted, obviously, by that time you should have a report, and if there are matters in mitigation of sentence that might be pertinent, you would certainly have an opportunity to present it. But at this point, where we are is the motions have been heard, all of the discovery has been provided, you and Ms. Smith have been given ample opportunity to discuss this matter amongst yourselves. You've had ample opportunity to discuss it with Mr. Saunier, and we need a decision so that we can make the best use of both the court's time, the prosecutor's time, and so that Ms. Smith can decide what she wants to do with the rest of her life, whether that's exercise her right to a trial or resolve this matter on a negotiated basis. Let me also advise you that after today, she's welcome to enter a non-negotiated plea anytime she likes, and the prosecutor obviously is welcome to drop the case at any point. So is there anything else we need to take up other than a decision?
Not from the state, Your Honor.
Thank you, sir. On behalf of the defense.
Well, Judge, I would just, again, I know you're going to set a trial date, and to me, it's form over substance. If we go ahead and set a trial date, but then don't allow the defendant 1 week to maybe take the plea offer, because she's looking at mandatory 10 years if she goes to trial and loses versus the 6.5 that's been offered. I just don't see the problem if we say, all right, we're going to go ahead and set a firm trial date. It's a firm trial date, but you telling us you got 1 week to work it out, and if you don't work it out, then we're going to go to trial, and that's all I would ask.
Well, Mr. Coker, I already gave you a date to work it out. That was today.
I understand.
And so, having not done that, at this point where we are is it is time to move to the next step in this process. And I will be candid with you and your client. The reason that these dates don't get reset is because what tends to happen is if I reset them without an extraordinary reason, it sends the message that you are better served to spend your time negotiating with the court than resolving the matters that need to be resolved. And so for that reason, while I hear what you're saying, it does not create a situation that is different than any other person who comes before me. Ms. Smith has been given all of the information that in this court's judgment, she needs to make a decision because all of the things that we can hear and resolve have been heard and have been addressed. The state has made its representation that it has made its best offer, and that even assuming the best case scenario with this report, that is not likely to change. And so for that reason, I'm going to have to once again insist that you and your client make a decision. Now, I'm neutral as to what it is, but today is the day.
Your Honor, could I have till the end of the day at least?
Certainly. You may have until the close of business.
Thank you very much.
Thank you.
Opportunity to observe a settlement conference. What's important here is the settlement conference is being conducted not by the judge who will try the case, but by another judge. You can have an opportunity to discuss. I know some of you may say, well, I can do them. Some will talk about the other procedures. But for this one, it's the non-trial judge. we will take a look at how can you proceed to get the parties to really focus on what are the issues that need to be resolved. You know, where is the pushback coming that this case isn't proceeding forward? They've requested a settlement conference. We know it's appropriate. Settlement conferences often do go on the personality of the judge, but personality aside, there are certain important steps you can take to arrive, when appropriate, at a resolution, or at least make sure that this is a case that is going to go to trial. So let's take a look and see how this settlement conference occurs.
Good morning, everyone. Thank you for coming today. We're present today. It's July the 7th, 2011, in the matter of the State of Arizona versus Lonnie Smith. We're present with Ms. Smith. Is that correct, ma'am?
Yes, sir.
Okay. Thank you for being here, ma'am. And her attorney, Mr. Sonner. Mr. Sonner, good to see you again. And also Ms. Russell, the prosecutor in this case, county attorney. Thank you all for being here. Ms. Smith, I want to make sure that you understand what will and will not happen here today. My name is Jeff Coker. I'm a retired judge. I retired from the bench about 5 years ago after 20 years on the bench doing these kinds of cases. And I'd like to explain to you what my role is here and what's going to happen so that you understand how this process is going to unfold. I'm not here to try to convince you that you should take a plea. I have no power to make the state give you a better plea. I have no power to make you take a plea, and you won't hear that from me here today. You're not going to hear me give you an opinion about whether I think you should take a plea or not. That's not my role. That's Mr. Sonner's role. And I simply don't have enough information to give you that. I wouldn't give you that kind of an opinion in the first place. But secondly, I don't have enough information to. I've read the court's file, and as you can see, there's hardly anything in there. It's just the charges, basically. Your attorney, on the other hand, has read all of the information. He's familiar with it. Your attorney is the one you need to look to decide whether you're going to take a plea today, not to me, okay? Now, why do they call me in to do these settlement conferences? I think it's real important that you understand my role here. They call me in because I can do something that your trial judge is not allowed to do. Here in a few minutes, Ms. Russell's going to leave the room, and I'm going to sit and talk with you and your lawyer. I'm going to hear what you and your lawyer have to say, and then I'm going to go into the other room and I'm going to talk with Ms. Russell and see what she has to say about her case. And then I'm going to go back and forth and back and forth. Not to twist arms, but simply to try to get information. We find that sometimes bringing the parties together, we can find a point where everybody can agree. And once we start building on that point of an agreement, quite often we're able to resolve our cases. But that's my role. I'm not here to twist your arm. I'm not here to twist the state's arm. I'm going to be acting kind of as a go-between. But I can do that. Your trial judge is not allowed to do that by rules of ethics. Your trial judge, if he meets with one party, the other party has to be present. And we've just found it sometimes works to a settlement if we're able to separate the parties out. So that's one reason. The other reason they call me in is because, and we think this is really important, we want you to be comfortable talking about your case today and not worrying about that it's going to get back to your judge. I never talk to the judges about the cases. The reason that they call me in as a retired judge is I'm not your trial judge. I will not be your trial judge. And you can talk about your case here today without fear that it's going to come back to hurt you later on. I have the ability to not only meet with the individual parties, but in the long run, if you decide to reject the state's offer, you're then going to go to trial in front of a judge that hasn't heard anything at all about what we talk about here today. And we think that's real important. We want you to feel comfortable that you can say whatever you need to here today without it coming back to hurt you in your trial. And then if you decide at the end of the day you just don't want what the state offers, perfectly fine. You'll go to trial in front of a judge who doesn't know anything at all about what we said. Does that make sense?
Yes, sir.
Okay, good. All right. Let's talk for a minute about your case. Ms. Russell, I note from reviewing the file that the indictment is one count of sale of methamphetamine, a Class 4 felony, and one count of conspiracy to sell methamphetamine, a Class 4 felony. Are these the charges that are facing the defendant?
Yes, sir.
Okay. Does the defendant have any priors or any other aggravating factors in the case?
Well, yes, sir, she does. According to our record, she has 2 illegible priors, which puts her in the 3rd category. She was also, at the time of this offense, on parole, and in fact, had just gotten released about a month before committing this offense.
Okay. What do you calculate the defendant is looking at under the mandatory sentencing provisions?
Well, Judge, if we can allege all the priors and that he was on parole at the time, we'd be looking at 10 to 12 years mandatory minimum. She'd have to serve 85%. If we were to prosecute under the meth statute, it would be 10 to 15 years, again, mandatory prison time, and even under the 85% rule, under either scenario, you'd be looking at 10 to 12 years minimum.
Okay, thank you. Has an offer been made, counsel?
Yes, sir. We have.
And what is that offer?
Well, we've offered to allow Ms. Smith to plead to 1 count of attempted sale of dangerous drugs. That, of course, is a Class 4 felony, but with only the 1 prior, the minimum would be presumptively 4.5 years up to an aggravated term of 6 years.
Okay.
But, Ms. Smith says she's not interested.
Okay. Do you have the, how's your case? Do you feel like you've got a pretty good case?
Well, we've got an officer, we've got the confidential informant, everybody's ready to testify. We've also got the buy on video, so this is about as good as it gets for the state.
Okay, thank you. Anything else, counsel?
Well, Your Honor, one of the reasons that we feel pretty strongly about this is because Ms. Smith has already been on probation twice, and the last time was for a drug offense. She was revoked and sent to prison. At this point, this case is well within our office guidelines, and really based upon Ms. Smith's priors, we don't have a whole lot of negotiating room. So this really is about as good as it's going to get from the state.
All right. Ms. Russell, thank you very much for coming today. If you would, please have a seat in one of the other jury rooms. I'll be with you in just a minute.
Thank you, sir.
Mr. Sonner, what can you tell me about your case?
Well, Your Honor, this is an example of the mandatories that are working against justice. My client in this case has a real drug addict problem. She knows it, but while she's been in jail, she's been under treatment, and she's doing very, very well for the last 2 months. And she'd like to have another chance of probation. First, she is the mother of 3 young children. They're being taken care of now by her 77-year-old grandmother, and that she just would do very well if she had one more chance at probation. She's been brought up short. She's never been convicted of anything other than drug crimes. Her problem is that she's a drug addict, not that all of her sales were just simply to feed her habit. She's been working very steadily. She's a very talented bartender, and she gets along very well with her customers. And I think that this is a case where she should have another chance.
All right, thank you. I will only promise you one thing here today, ma'am. If you go to trial and you lose, your judge is going to follow mandatory sentencing because he has to. When we take an oath of office, we swear to uphold the laws, the Constitution of the state of Arizona. This is one of those laws. So I know some defendants, they hear about mandatory sentencing from their lawyers and they just don't believe it. Well, I'm here to tell you it is the truth. And I can't change it, your judge can't change it. If you roll the dice, you're looking at somewhere between 10 and 12, maybe 10 and 15, depending on how the prosecutor comes after you on that meth statute. What you need to be focused on here today is the offer is with 1 prior, 1 sale, it's 4.5 to 6 years. And that's prison time, but it's 85%. It's not flat time. So you need to keep that in view versus 10 to 12 and maybe 10 to 15. The 10 to 12 would be soft, would be 85%. The 10 to 15 would be flat. I just want to make sure you understand it's 4.5 to 6 versus 10 to 12 and maybe 10 to 15. That's what you have to decide upon here today. And you ask yourself, well, how do I make that decision? You make that decision based upon the answers to 2 questions. Number 1, can I win? And number 2, how do I prove my case?
I've prepared 2 documents for American University and the Bureau of Justice Assistance on the topic of case flow management. They take 2 different perspectives, and I'll share each one of them with you because I think they both can be useful to you and to the staff in your court. The first is entitled Improving Criminal Case Flow. And the content of this very brief, I think it's possibly 12 pages long, very brief document, includes reference to and explanation of the elements of effective case flow management, the fundamentals that we know are essential and which have been proven and tested over time. Also references effective criminal case management practices that have been documented and been shown to be really essential to having an effective system. Possibly most importantly, it talks a bit about the method or the means by which you would go about trying to implement these in your court. And it describes the importance and emphasizes the importance of a collaborative planning process. And it does describe step by step the process through which you would go to identify the problems that may exist in the system, develop possible solutions, implement those solutions, and then measure your success in meeting the goals that you've set. And it starts right at the beginning of the process. And so when you think about this, this is almost a no-brainer. It says early availability of the arrest report is an important management practice. What happens if you don't get the arrest report on time? Well, first of all, okay, we can't, the prosecutor can't assess the case. Prosecutor doesn't know what offer to make for disposition. The defense doesn't know what response to make because the full arrest report is not available. So things can start to go wrong right at the front door if you don't have a timely provision of the arrest report by the law enforcement. Early attachment of counsel and prompt client interviews. You can see why that's important. You need to get counsel attached early, and you need to talk to the defendant at a very early time to start to see where the case is going and to be able to have a meaningful dialogue with the judge at the first case management conference. Realistic charging is an important element. I mean, and we could debate this for a long time, but as you know, overcharging has long been cited as a cause of delay and as an ineffective practice. And so when you're working in consultation with the criminal justice agencies, this is a discussion to have about charging what can be proved and setting the expectation that the offer is not going to get a lot better as time goes on. Early exchange of information between prosecution and defense. This sometimes is absolutely the basis for reaching an early disposition in the case. And when the judge at the earliest case management conference inquires into the status of discussions and where has discovery been exchanged, and if not, why not, you are making significant progress toward disposition. It's the court setting the expectations of the lawyers and the litigants or defendants about what's going to happen, and that we're not going to let this case drag on. We're creating that expectation of timeliness. We want to assure what one presiding judge has called same justice earlier. We're going to get the same just result, but we're going to get it at an earlier time. And that emphasis that the trial judge, we call him a trial judge, although there probably won't be a trial, but the management judge imposes here sets the tone. Good case screening by prosecution, defense, and judge. And this is occurs very early, or should occur very early in the case, to determine what is this case about, how complicated is it, what's it going to take to dispose of it, and what is the next event and when should it occur. And this is a dialogue between the parties to the case. So everybody brings all their knowledge to that point, to the conference, and decisions are made. We find the best systems are those in which the prosecutor is pretty realistic in offering a negotiated disposition, and it's pretty clear that that offer is not going to get better over time. It's not only important to have a credible date and a date that one can be assured is going to go forward, it's also important to make it clear what's the purpose of that event. The next event is a case management conference. And at that case management conference, we're going to achieve the following 3 things. And this is what I expect the lawyers to do before they arrive at that case management conference. We don't, for example, want to have calendar calls where all the cases scheduled for the next 6 months are brought in and asked to make some representation about their readiness in 6 months. You want events that have a particular purpose, and you want to accomplish that purpose, and you want to make sure that it's moving the case toward disposition, and if additional activity is required, you establish at that time what that activity is, and you set a firm date for it. A practice that is not universally embraced, but which many courts feel is very effective, is to wait to schedule a trial date until it's clear that a trial will be required. Again, going back, remember that in many courts, only 2%, 3%, 5% of cases will require a trial, and yet the historic practice and the common practice still today, I think, is to assign a trial date very early because you don't know which cases filed are the ones that are going to require a trial date, and the arguments that is made is that you need that trial date to force a disposition. Well, in the days when we didn't have intermediate meaningful events and we didn't have intermediate time standards, that may have been true. But now what we have are the meaningful events and we have the management of the time between events. And what's important is that every case, as I said earlier, has a future date certain for a purpose certain. In other words, no case is ever without a future action date assigned. So what some courts have concluded is you don't need a trial date set, a trial date that everybody knows is a fiction because this case probably is not going to be tried. But you do need a next action date all along the way. And if you get to the point where it's clear that this case is one which cannot be disposed of through settlement or by a negotiated disposition between the prosecutor and defense, then you set the trial date. And you don't then have to set it 6 months out or 9 months out or a year out in civil cases. Your calendar is open for the setting of this case because you haven't filled the calendar with all the trial dates in cases that never will be tried. So it's something to think about. The second document is designed for use by court staff or staff of the Administrative Office of State Courts if they happen to provide this sort of service, or by a consultant that you might bring in to assist you in assessing the current condition of your caseflow management system and identifying problems and defining solutions. It runs from the beginning of the caseflow management review all the way through the process. The first one is preparing for the review. It's important for those who are doing the work to consult closely with the leadership in the court about the expectations for the outcome. You need to know right at the beginning, what outcome do you expect? What product do you expect? What information do you expect to have as a result of the caseflow management review? Stage 2 includes the real documentation effort, and I call it system documentation. And system documentation is simply a way of saying you have to find out what's going on. You have to find out how the system currently works, who does what, how long does it take, what are the problems, and you obtain data and information through a number of ways. We describe using interviews with court staff and judges as a primary source of information, and in the process of getting those facts and describing how the system works, this document suggests that you then draw a flow diagram, a process diagram of what you've learned. And one of the reasons for doing that is it helps you quickly see where you have gaps of information or understanding. And it's always been my feeling that if you don't understand the system well enough to draw a picture of it, in other words, to draw a flow diagram, then you don't know enough about how it actually works. But when you're doing these interviews, you're not only going for factual or what we might call objective information, you're also you also have your antenna up for the subjective information. You learn something about how the people in the system think about the case flow system as it now exists. You learn something about what they think ought to be changed, and you can gain a lot of good information, which you would call subjective, by listening to people's attitudes and beliefs about the current process. And thirdly, you're also starting to assess the organization's readiness for change. Who in the organization believes that improvement is needed? Who in the organization believes that improvement is possible? Who in the organization might be the most resistant to considering the possibility of change? So this data gathering or interview process is really very important, and it's discussed at length in this document. Data gathering also includes observations of proceedings. It's one thing to talk about what the events are and what the process is. It's another to actually be granted the opportunity to observe what is actually done in process. I can remember an example from some years ago where we discussed with the presiding judge the fact that we wanted to come in and observe the criminal assignment court. And we were going to document it, and we got his approval. We said we were going to take notes. He said, well, you're welcome to do that, but you won't find anything. I mean, I run a very tight ship here, and I don't continue cases unless exceptional cause is shown, and so forth. So we did it. We went in and we observed the process over a lengthy period of time, and we were able to come back and say, to the judge's surprise, 75% of all the cases scheduled are continued at least once. And he was very surprised. And you don't get that unless you go in and watch the process and know what's going on. It's also important to review the rules and statutes that govern what's occurring in the court currently. And it's important for you to read them and understand them and be able to compare them to what you're told. For example, you'll often be told, well, we can't do that because the statute requires us to do something else. And then you read the statute doesn't say that. And so you need to be able to verify through your own research the veracity of some of the assertions that are made, or some, especially the reasons that are given for why, oh, we couldn't do that because court rules forbid it, or we couldn't do that because the state statute forbids it. So it's important for you to gather those rules. The document also provides guidance on collecting data. And usually, when you go into a court, you're not going to find a lot of data of the type that you need to collect to understand how the court is currently managing its caseflow process. And so it's very likely that the person undertaking the caseflow management review will have to initiate a data collection effort. And this document then presents suggested forms to be used or adapted for use. It suggests the data that needs to be collected so you really get a good picture of what the process is and what the outcomes are. Then we describe how you would analyze the data that you've obtained and how you would formulate and present conclusions and recommendations. I feel it's a very good guide to assist somebody in undertaking a complete and thorough analysis of a court. And it contains a number of appendices, a lot of forms that you could use. Effective caseflow management helps create the expectation of timeliness in one very important way, and that is by creating a system of credible trial and hearing dates which the lawyers can rely on. In other words, if the judge sets a date for a motions hearing, the motions hearing occurs as scheduled. If the judge sets a date for a case management conference, the case management conference occurs as scheduled. Otherwise, you wind up in a situation where the court has too many cases scheduled, lawyers know this, and their propensity to prepare is eroded by their expectation that the event may not occur even though the date has been set and notice has been sent. Many courts schedule far more cases on a given day for, let's say, settlement conferences or trials or motions hearings than can actually be met. The result is that the lawyers begin to learn the culture of that court is, well, yes, I have a date assigned for the motions hearing, but it's unlikely that that date will occur. I don't necessarily have to be prepared, and if I actually am reached on that date, I'll just have to ask for a continuance, and probably the court will grant the request. And that is a culture that you really have to eliminate in your court in order to have continuous, effective court supervision of case progress. Now, one of the ways that courts develop credible trial and hearing dates and assure the availability of lawyers is by setting the dates in consultation with the lawyers. And if you've had early judicial intervention in the case, let's say a case management conference, there's a discussion about how much time the case is going to require, what the events are going to be, and the dates for completion of activities, for example, discovery, are set based on input from the lawyers and supervision by the judge. And that's much more realistic than simply sending a notice to the lawyers of a future date that the court has picked at random from its calendar. So, two things. The court has to have a system that it creates the expectation of timeliness by guaranteeing that a case set will be reached on the date set. And it also has to have a policy with respect to dealing with continuances. And the policy has to be clear to the lawyers. They have to understand what are not acceptable grounds for continuance. And they have to further understand that the judge will make inquiry as to the reasons and the necessity for the continuance. When did this necessity arise? What efforts have you made to avoid the continuance? What is the earliest date you could be available if we do in fact have to continue the case? How about next week rather than next month? So by creating the system of credible dates and creating the expectation of timeliness and creating the expectation that continuances will not be easily obtained or routinely granted, the court makes a very important step toward managing the progress of the cases and ultimately achieving a timely disposition. One other thought I'd like to leave you with about continuances concerns actual calendar management. So often when cases are being set for events, you know, you're paging through or looking at, now you look at your computer monitor and you look for an available date. And frequently we hear, well, we don't have any dates available for the next 3 months, or we don't have any dates available until, you know, name the time. Continuances actually wind up jamming your calendar with cases that, the same case over and over again. If you think about it, the first time you set a case, it takes 1 slot on your calendar. If you continue it, that same case has taken 2 slots on your calendar. If you continue it again, that same case is taking 3 slots on the calendar. So when you look ahead to try and find a date to set another case, your calendar appears to be filled up, and in fact it is filled with cases, but many of those cases wouldn't be there if you hadn't continued them the first time or the second time. I consider it an exercise in how to increase your trial calendar. The more cases you continue, and the more times you continue those cases, the more you're going to crowd your calendar with cases that could have been disposed of early, and the more you are going to take up slots that could be used for new incoming cases, and that's part of what contributes to delay.
One of the big things that we found was the lawyers want predictability. The chaos that our system was, and most systems are, that don't have a Caseflow system, there's no predictability to it. You don't know whether the hearing's really going to go or not. You don't know what's going to happen at the hearing. Even though it's set, you don't know whether it's really going to go. The other side, are they going to be ready? Should I be ready for this hearing that I don't think the other side's going to be ready for? Is the judge going to cancel it? There's no predictability to the system. It cost my clients a lot of money to get ready for hearings that never accomplished anything. And so that was the carrot we held out for attorneys. we will give you some predictability. We will give you that predictability. And one of the things that we had to accept ourselves in doing that was reaching out to the lawyers and saying, when we were getting ready to set a hearing, what's good for you? What time can you be there? These are the goals for the next hearing. You're going to have disclosure made. You're going to do those witness interviews. You're going to have discussed a plea. How long is it going to take you to do that? We didn't do that before. We just automatically set it for 3 weeks, 4 weeks, 10 weeks, whatever. We just set it with no input from the lawyer. And we said to the lawyers, we are going to get your input. And I have kind of adopted a phrase over the years that the lawyers now have heard from me 1,000 times. Do what you say you're going to do when you say you're going to do it. And if you do that, the system will work well. If you don't do that, the system starts to fall apart. Because that's why continuances happen. They don't do what they say they're going to do when they say they're going to do it. And that's key to it. And the pitch that I made to the lawyers is, I'll get your input on when you can do things, and if you tell me, Judge, I'm on vacation, or my wife's having a baby, or I'm having a baby, or whatever the explanation is, we'll work with you on that. But when you come back, you will have done what you said you were going to do when you said you were going to do it. And then there's not going to be a continuance. We haven't eliminated continuances, but we've reduced them so significantly that it's just been a boon for us.
Another important element that has been documented very well over the years is the creation and observance of certain time standards and goals for processing the cases through the court. And this does not principally refer to the idea of having a disposition time standard. Yes, disposition time standards are important, or disposition goals are important, but what is probably more important is the setting of time standards and goals for the time between the meaningful events that I referred to earlier. We said that it's important to create meaningful events that either dispose of or make significant progress toward disposition of the case, and it's important to manage the time between the events. Now, if we have some standards for the time between events, well, that's the best kind of management we have for managing time. So it's important to have those time standards and goals. One example is the following. If all you have is a disposition time standard that says, for example, all civil cases must be disposed of within 18 months of filing, or a disposition time standard that says 95% of criminal cases must be disposed of within 6 months. That's fine. It gives you an idea, it sets the outside parameters, but you don't know how you're doing at any given time. All you know is at the end of the year you measure the time to disposition and you say, oh, we didn't quite make it with criminal cases. It's too late to do anything about those cases. They're finished. If you have intermediate time standards against which you can measure the progress of cases during the life of the case, you're able to tell whether you're falling behind or doing okay, and you're able to tailor those times between meaningful events in such a way that you are largely assured of reaching the disposition time goals that have been set by the court or which exist in the rules in your state. So time standards are good. Overall time standards are important, but managing the time between events and having standards for the time between events is more important. Having an effective information system that can provide timely information on the status of your caseload and indeed the status of the individual case at any given time is essential. It's really important to think about the ability of a good information system to tell you whether you are achieving the goals you set for your system. When you set time standards, or when you set the intermediate time standards that we've talked about earlier, you need a way to know whether you met those goals. Setting the goals is just not enough. And as I've indicated, learning at the end of the year that you did or you didn't quite meet the overall disposition time standard is quite a different thing from monitoring the time between events as the case goes along. You have to have a way to say, did we do it? We said we were going to do this, did we do it? And the information system allows you to do that. Next most important is, if we didn't achieve what we said we wanted to achieve with the plan, why not? And if you don't have good data, you can't answer the question of why not. Where did we slip up? Did we continue the case management conference too often? Did we allow too much time between the motions hearing and the ruling on the motion? So an effective information system is another key element of an effective overall case flow management system.
We had no data. We didn't have computers in the clerk's office. We had to hand count everything. We had no information to show that we were doing a good job. All we had was everybody saying, well, we're working as hard as we can work. There are no more hours in the day. We got funding for a computer system, which then allowed us to collect the data so that we could determine our case aging. Judges are very competitive, like most lawyers are. The one judge that just sort of dug in his heels and said, I'm not going to do this, when he started seeing his statistics on how long it was taking him and how many hearings he was having versus the rest of us, he became one of our most ardent converts. Became just absolutely wedded to case flow management because he saw how effective it is in getting cases resolved earlier, and therefore it gives us more time.
You've emphasized the importance of having information about actually how things are operating, and I think that you can't emphasize that enough, the importance of having the data, the importance of judges knowing actually the impact of the practices that they're applying. And you really, no judge wants to be at the bottom of the list.
That's exactly right.
The slowest or the largest inventory. And you don't necessarily have to say a word about it. You just provide the information, and it's very powerful.
Every month they get a report that tells them where they are, how many cases they have. Say, I want every case in there that's more than 120 days old, pull it. Let's find out what's going on. Because one of the things about case flow management is you want to avoid those black holes. We call them black holes, where cases go and people forget about them. You send a defendant out for a mental health examination and the doctor forgets to send you the report back. Nobody's got that thing scheduled for anything. It's real educational and helpful in helping a judge manage his or her cases, because then you've got that data that says, well, this case has been sitting around for a long time. Oh, the guy's in the state hospital being restored to competency. I can't do anything about that. Or maybe the defendant took off. Maybe he's on warrant status. Well, let's take it out of our pending caseload and put it on warrant status. We went through a period where our numbers started to slide. And then we realized we had all new prosecutors, all but one of the defense attorneys was new, and every one of our judges was new. And even though we had been doing the training, they didn't have the fire in the belly, if you will, that we had from 1994, and we had to figure out a way to rekindle that in them to say, this takes work. It takes work to keep pushing this. And it's not something that you do once and then you don't ever have to do it again. It's something you work on every single day. We have the data now coming out, which any presiding judge, whether I'm around or not, is going to look at that and say, whoa, wait a minute, because that's what happened recently. Our presiding judge looked at the data and said, whoa, there's something going on here. And he then took the initiative. And I think that's really critical, is to have that data, have the reports, not just the raw data, but have it in a form that the judges can look at very quickly and say, our length of time to disposition is getting too long, we've got too many people waiting pre-trial in the jail, et cetera, et cetera.
It's been said that no one person or agency can create a successful system, but it only takes one to make it fail. And for that reason, you want to be sure that when you plan the case flow management system and as you monitor its effectiveness, you involve all the agencies, and let's use criminal justice as an example. You involve all the agencies in the criminal justice system in the planning and in identifying potential roadblocks and in monitoring the effectiveness, and in coming back together periodically to answer the question, how are we doing? Are we doing what we said we'd do? If we're not, what are the problems we've encountered? We have to be aware of the importance of continuing interagency consultation. Yes, the court is in the leadership role, and in undertaking court reform, caseflow management reform, the court does have to take the leadership role, and usually the presiding or chief judge spearheads this effort. But the court can't do it alone. But working together, you find the common ground, and one of the interesting things that you find when you work with the other agencies in, let's say, a criminal justice task force or criminal justice planning effort, you find out that the goals of each one of the agencies essentially are the same. There may be some details on which points of view differ, and there's very often in the planning process you have to do a lot of negotiation and some give and take about preferences that one agency might have about how they deploy their personnel. For example, if they have somebody who's a specialist in death penalty cases, or they have somebody who's a specialist in certain type of motions, sometimes you have to negotiate and work out a system that works for everybody, because there is something in it for everybody, and it benefits the court, benefits the public, it benefits defendants in criminal cases, and it benefits the prosecutor too, to have a system which, as we've said, is predictable, is timely, is fairly applied, and is well understood by everyone, and everyone has had a role in planning it, and everyone has something in the fight, you might say, in terms of whether or not it is a success. Talk a little bit about how the judges received this. Was it difficult to get everybody on the same page and applying the same techniques and principles to their caseloads?
Well, there was. Initially, I thought that caseflow management was something that the judges would just simply do. But after talking with the consultant at some length, I realized the wisdom that I like to say we're a three-legged stool. There's the judges, there's the prosecutors, and there's the defense attorneys. But there's also more legs to the stool. There's law enforcement, the sheriff's department, who controls the jail. There's the clerk of the court. There's probation. And the more I got into this, the more I realized that all of these people are cogs in the system, and they all affect the system in how they do their job. And if their job is affected by what I'm doing, or vice versa, then we need to take that into consideration. There was some apprehension. For instance, the prosecutors were apprehensive about it because they felt that we were going to take some of their discretion away if the judges started managing the cases. The defense attorneys were afraid because they were concerned we were going to rush justice, that somehow caseflow management was all about jamming cases through the system faster but not better, and not having justice. There was concern by the probation department whether they were going to be able to meet our needs. The sheriff, similarly, the clerk's office. Are we going to be able to keep up with whatever it is that you're doing because we had been starved for resources for so long? There was some apprehension by them about whether we can do this. The consultant convinced me that by bringing all of the players in, yes, initially we might get a little bit of sniping at each other because it had never been done before, and everybody had some built-up resentment for over the years. But once we got through that and everybody realized we weren't going to do this in isolation, we were going to do it with them, a cooperative spirit developed that was just, it was magic. It just, from that point on, everybody said, yeah, let's do this. Let's make this work. So it didn't rely just on me or the court administrator or one of the other judges. It became a community effort to improve the system.
And did you find that to a great extent everybody's goals were really the same?
We did. By having fewer hearings, helped the prosecutors who was shorthanded, helped the jail who was delivering prisoners, helped the clerk of the court who couldn't keep up generating the minute entries, helped probate. It helped everybody. So we did have a commonality there. And we found that by identifying the goals, we then got everybody's sort of buy-in. Those are our goals too. It was something we were all doing together.
as I understand it, you formed a task force
We did.
and representative of all the agencies. Can you tell us a little bit about how that worked and how the task force did its job?
We brought the key people in, the head of the county attorney's office, the county attorney. We brought the sheriff in and their chief deputies, the clerk of the court, the judges were there, probation was there, and we had a representative from private bar as well, the private defense bar as well, and we had them all in the room, and we said, we're going to start a series of meetings. And we did. We just met week after week after week, first identifying problems and then identifying solutions. Again, we met with some resistance at first, but over time, once we understood that everybody's goals were the same, it began to flow very well.
What were some of the subcommittees that you formed?
We formed subcommittees because we found the big group to be a little unwieldy. We had the JAs, the judicial assistants. We had the Minute Entry Reform Committee. We had a process committee that whose job it was to go through and identify where are the glitches, where are the impediments, where are the things where things get hung up, why are we having continuances, that sort of thing. We had a detention and delivery subcommittee. We had multiple subcommittees who then drew up reports that then reported back to the task force. It was wonderful because they gave us the on-the-ground information, empowered the people that were going to be most affected by what it was we were proposing, and let them help us design the solutions. We found that when we would set the next case management conference, because of the problems in the clerk's office, the minute entry setting that next date might not get sent out until right near that next date. So one of the clerks said, well, why don't we just give them notice in court? So now we have a little pad that has a carbon on it. She writes the date of the next hearing and it's handed to the defendant. It stopped all this nonsense about lawyers coming in and saying, I didn't get notice to my client, or my client didn't get the minute entry, my client didn't get notice of the next hearing. You got notice during court at the last hearing. It's dropped our failures to appear by defendants just almost non-existent. The county attorney came in and said, look, I'm just, in most of the cases, I can probably still get the plea offer at the arraignment, but in some of the more serious cases, we're having trouble because I just don't have the staff anymore. So we said, okay, we'll change the system to where the plea now comes at the first case management conference. And he was very appreciative. Everybody said, can we make that work? Yeah, and then we pushed a couple of other things off from that first one to the second one. We made an adjustment simply because life on the ground said he couldn't keep up with it. And if the alternative is for him to make ridiculous overcharging pleas at that first plea offer, we'd much rather have a realistic plea come from the prosecutor at the second CMC than have one that isn't even reasonable come from the first one just because he hasn't had time to investigate it.
Did you form a backlog reduction committee? It strikes me that in undertaking these changes, you're forecasting a new system to apply to the cases that are filed, but in the meantime, you still had an inventory of cases awaiting disposition, and you had to deal with those simultaneously in a sense.
It was one of those aha moments when we formed the backlog subcommittee because the consultant asked us, what's your case aging? We didn't know. So we formed this backlog subcommittee whose job was to go in and physically, one by one, count the files, record how old they were. To my absolute shock, I found out that in my division alone, I had over 300 cases more than 6 months old. And every division had similar numbers.
And what was your time standard?
We didn't have any time standards. And that subcommittee, the backlog subcommittee, then came up with a solution. How do you address those cases coming in the door at the same time dealing with the old cases that have piled up on you? Each of the divisions took one lunch day a week. We directed the prosecutor and the defense attorney, public defender and or private bar, these are the cases we're going to address today, and we would put 50 cases up and we'd say, these are the cases we're going to address today, bring your box lunch, we're resolving these cases. And we did. It took us about 4 months, but we got rid of our backlogs.
I think a very important point is that you created the task force early on to do the planning. And you did this in 1994. And to this day, that task force has continued to meet on a quarterly basis to consider problems, to resolve issues even between agencies, to just continuously assess how the system's operating. And I think that's notable. I think that's unusual, and I just wanted to highlight that because I think that's a real strength of your ability to sustain change over time.
The judge, the presiding judge, is usually the head of the task force, and that way we get better attendance. But everybody can come, and anybody can come in and say what's bothering them or where their problems are. If it's a funding issue, then like the clerk's office came in and we needed some new readers, we went to a barcode system to keep track of our files because losing files is a problem in every court. And we were able to work cooperatively, come up with a grant to get her some readers so that we could implement a barcode system for the files. And it's just marvelous, the sense of cooperation and the spirit of cooperation of, hey, I've got a problem, I can't solve it, but maybe the task force can help me.
Do you believe there's an economic impact of the practices that you've implemented and your ability to reduce the time it takes to dispose of cases and the number of events that are rescheduled?
As far as ripple effect, positive ripple effect in other agencies, the jail particularly has been, and of course they're making fewer trips from the jail, so they've been able to cut down a little bit in their detention staff. Because we're having fewer hearings, they've been able to reduce their bed days in jail. They've been able to take that money and use it for a treatment program in the jail, which has been outstanding. The clerk's office has been able to not have to hire as many people simply because they're not generating as many minute entries. We're keeping probation pretty busy. But one of the benefits that probation has received is we've gone to a consolidated revocation court so that the probation officers are not wasting their time sitting around in courts when their probation revocation hearings don't go. Yeah. So it's been they are very, very much in favor of it. Yeah. We were doing so many things before that we didn't really need to do because we were doing them over and over and over again.
What you've described sounds like a lot of work, and in particular a lot of work for the judge, working through the backlog of old cases, trying to start timely with the new cases. And the question that occurs to me, and the question that I would think judges would ask themselves when they hear about your experience, is that is a lot of work. Why would I want to do it? Why would a judge, what is the reward for a judge to undertake a program like this?
That's an outstanding question. And I look at how much better we do our jobs, how much more satisfaction, job satisfaction, and candidly, how much pride all of our judges have in our system, and the lawyers, and the staff, the clerk's office, how much pride they have in our system. When I have a lawyer come up to me who practices in a multi-county jurisdiction and say, can you go over to so-and-so adjoining county and teach them caseflow management because they're in chaos, gives you pride in your work. Job satisfaction is through the roof. The judges feel like they're doing a good job because they are doing a good job.
As a result of the changes you've made, have you received appreciation from the public and recognition that the system is better now than it formerly was? And is that a source of satisfaction to you?
Absolutely. One of the things we did in '96 is we did a court planning process. We called it Project 2020. We were going to find out from the community what the community thought. And we got the standard things. Takes too long, it's too expensive, I don't have much input into the system, et cetera, et cetera. We have, in the latest poll that we took, our approval rating has gone way up. Our disapproval rating is almost non-existent. We also had several articles in the newspaper about what we were doing. And of course, all of the lawyers are members of the community, and so they go tell their friends and neighbors about the good work that the courts are doing. And the combination of the newspaper and then just the word of mouth communication about how good our court really is just makes us all feel good. And there's an attitude that we'll look at anything that is going to slow this process down or make it not work well. We're going to look at it. It's just that once we got rid of that adversarial, the judge is my enemy, the prosecutor is my enemy, or the defense is my enemy, and I've got to fight him at every single point. Once we got rid of that notion and said, wait a minute, cooperatively, there's a lot we could do together. Once we started on that, we took so much of the tension out of the practice of law. It became so effective in the criminal, which is what we brought the consultant in for. Within 2 years, we were doing criminal case flow management in civil and domestic relations, and currently in our jurisdiction, we meet every ABA standard in civil and domestic relations.
We've talked about the most essential elements of effective case flow management, and you may be wondering, sort of, so what? Does this really make a difference? How much difference does it make in a court? And that's a particularly important question to ask right now, considering the current economic times and the efficiency and economy that can be achieved by effective management is a good question at any time. To review just a couple of the points that we discussed, we talked about continuances. And if you think about the cost that may be involved in continuing a case, which people rarely think about actually, it can be substantial. One court, they wrote down all the time, all the activities that were required clerically and judicially and to process a continuance, and they realized that it took the time, in a year, it took the time of the equivalent of one member of the clerical staff simply to process clerically the continuances. There's an economic issue. If you think about how long defendants stay in jail, in pretrial detention, waiting for the outcome of their case, you can imagine that reducing the time to disposition will dramatically reduce the jail population and reduce the cost of incarceration. And as one judge said one time, you have a choice. You can either dispose of your cases earlier or you can build a bigger jail. And you can actually work that out mathematically and see that that's not an overstatement. I have just a few practical results from some courts that I've worked with. In one court, they reduced the pleas on the date of trial by 75%. Now imagine the economy that was achieved by that. First of all, it means that the cases were disposed of earlier. Fewer events and fewer appearances translates into less money spent on the part of the court, on the part of the parties, witnesses, lawyers. So that was a great economy, reducing the pleas on the date of trial by 75%. Trial settings per case were reduced by 2/3. In other words, they cut the continuances, which means they drastically cut the cost. And as you know, sometimes you lose justice through continuances because sometimes you get to the point where the witnesses say, I can't afford to come to court again. And that threatens the achievement of the just result for sure. Trial calendars in this particular court were reduced from an average of 24 cases a day down to 6 per day. And that goes back to what I said about the continuances. You can either fill your slots with the same cases over and over, or you can have new cases being scheduled and disposed of. Again, on the criminal side, in one court, they reduced from 72% to 31% the number of cases that took longer than 90 days for disposition. Again, a justice issue and an economy issue. And finally, again referring to the jail overcrowding issue, in this same court, within 6 months, pretrial jail stays were reduced from 173 days on average to 55 days. That is astounding. They won't be building a new jail in that jurisdiction.
About 45 years ago this summer, I was asked to teach a course in court administration at the National Judicial College. I had just come from a session with the United States Department of Justice in which we were attempting to identify the purpose of each of the divisions. And we'd ask the lawyers and the staff members, why do we need your division? What does it do for the government or for the people of the United States? So when I got to Reno to teach the class, I had the same thing in mind. And so I started asking the judges in classes of 30 what the purposes of courts were. And they answered, and we wrote it down on the blackboard, and we kept track of it, and then at the end of an hour we sorted it out and made a list of all the purposes that they came up with. So what I'm talking about today are the purposes those judges and court administrators came to in class in small groups over a period of about 10 years. And of course we've used these many times since then in larger groups. And we've never found anyone who had a substantial difference when they looked at them. So let's talk about them. The first of those is to do individual justice in individual cases. That's quite a mouthful. It's a rather complex idea. What do we mean by individual? Well, the Constitution of the United States provides for the jurisdiction of courts. They really say there must be a case or controversy. They can't deal abstractly with a proposition put to them. They don't give advisory opinions except under some statutes that have been passed in the last 25 or 30 years. Courts deal with the case before them, and only the case before them, and don't apply the logic beyond that point. So the individual word is important. Cases and controversies is important because it means it's limited to a dispute. Think about that. The adversary system is built into the Constitution. Without an adversary question, we don't have jurisdiction in the courts. The next part of that is to look at justice. People have been arguing since Plato's time about the meaning of justice. In American courts, I think you can simplify it. It means applying the law to the facts in each individual case. And as a matter of fact, we don't have much trouble with the law. We have multiple methods of appealing a mistake of law. That's what courts of appeals are for. But in fact, the facts are a one-time shot. What the trial court finds about the facts binds the system throughout. And we have trouble with that because we are, strangely enough, a memory-dependent system. Our method for testing whether something is true or false is to cross-examine or confront the witness. Matter of fact, the confrontation's built into the Constitution. So we have this way to identify evidence. Even records kept in the ordinary course of business must be identified by a person who can say, I know that was done properly. And we test it oftentimes by looking at whether it's properly recorded to determine whether it's admissible. It's clearly a memory-dependent system, and we know a lot about memory. First of all, we know that it diminishes with time. There's really no dispute about that. If we were to start today and tell everybody in the room something and ask them to come back tomorrow and tell us what they were told, we'd lose something, wouldn't we? How about waiting 30 days or 60 days or 90 days to tell people about it? But there's something even worse, and that is that the human mind can't stand a vacuum. The human mind fills in the facts it didn't ever see, taste, or smell. And it believes those and will test in a lie detector test on whether they're telling the truth because they believe it's happened. I don't need to dwell on this very much. In a memory-dependent system, justice, the very purpose we think of first for courts, can be lost by time. Or to put it differently, time is a justice measure. So when you're keeping track of when something happened and the next event and the next event, and you see things put off over and over again in a court, you're really looking at the loss of justice in the system. Well, the next basic purpose of courts is to appear to do justice in individual cases. You think that's the same thing? It's very different, because our system is based upon people relying on what courts will do. If courts get it right all of the time, if they get their evidence in a prompt way, if they decide promptly, if people are sentenced in a proper time, the courts appear to do justice. When it's a long period of time between when it starts and when it happens, people lose confidence. This is my proposition. The law works because people trust it to work. You can't litigate every case, not every building that goes up. But the expectation, the trust of the people in the courts determines whether it works. And that appearance of justice, like justice itself, is rapidly lost when the courts delay and drag cases on over long periods of time. Think about that. The next purpose of court is to provide a final resolution of legal disputes. Well, don't they do that by doing justice? No, it's a whole different two-dimensional problem. First of all, we have a value in our system which actually rejects justice on occasions. If I say the word finality to you, those of you who have some legal experience will say res judicata, collateral estoppel. What are those doctrines? They say even if we find evidence to show a case was wrong, it was badly decided, we won't open the case. Finality is more important. The final resolution is just as important to many people as the justice itself. Why? So people can get on with their lives. We don't expect things to be litigated for years and years. My short experience in Europe and in the countries following the European system would testify that our policy is very important, because they can litigate many cases for many years because they don't have the same doctrine of finality. Now, the second aspect of providing final resolution has to do with the fact that we enter the government into the enforcement of our judgments. If we didn't have that, if people just got a resolution and then had to go out and fight for the enforcement, we would have the same problem we have. We'd have anarchy. People would take the law into their own hands. They want the surety of law. If they don't get it by a court that enforces its judgments, the final resolution of legal disputes, they will go out and try to do it themselves. Now, the fourth purpose, to protect individuals from the arbitrary use of government power. I know in many of you that conjures up a picture of history. That's what Magna Carta was designed to do, to protect the peers of the realm from the arbitrary king. It's a basic doctrine of any legal system that isn't dependent upon the whim of people. In our Constitution, we enshrined a whole bunch of ideas like habeas corpus, ex post facto prohibitions, due process of law. What was that about? It was to protect the people from the government, from the courts, if you like. You've got to follow these procedures. You've got to observe these rights. Congress can't pass a law unless it's specifically authorized. And that's about protecting individuals from the arbitrary use of government power. It may be the one that distinguishes our whole government system most from most of the rest of the world. It means you can't have a dictator because all people are under the law. You could recite, all kinds of things, eminent domain and other areas where this is brought into effect. But it sits very high on the list of important purposes of courts. Well, a fifth one might surprise you. We don't talk about it very much. The fifth one has to do with making a formal record of legal status. Administrators immediately know about this. We spend about 65% of the court budget on making a formal record of legal status. The court reporter taking it down, the clerks making sure all the papers are in right order. In a sentencing, the judge's recital of the litany that says you do this willingly and without any impositions on you to make you do your plea of guilty, which accounts for 95% of all the criminal cases. You see what we're talking about? It's the judicial responsibility and purpose to make that record. People's lives depend on what judges decide or what gets recorded in the court. You think about two big areas of the law, the two highest numbers of cases, traffic and divorce. Almost all of that is about making a record, not about deciding what the disposition is going to be. Now, the next three of these purposes are based upon the judge's discretionary power in criminal cases. If there were no discretionary power, we might not include these. But in all criminal systems, judges exercise discretion, and of course prosecutors do too. So we have in the system a control over that discretion in sentencing. The first of those is to deter criminal behavior. I want to make this a distinction. Deterrence is not about the person in front of the judge for sentencing. Deterrence is about what the rest of the world sees happens to people who are sentenced. Deterrence, we used to laugh about when I was in law school. We'd say there isn't really any deterrence, it doesn't work. And then I had a good police officer remind me once. He says, well, did you ever get stopped in a speed trap? And of course you sit there and, well, almost everybody has. Well, why do you slow down the next time you go through? Because you're certain that if you go through there too fast, you're going to get caught and punished. That's a deterrence, isn't it? I had a better illustration some years ago. I was working on a commission for the United States Internal Revenue Service, and we were talking about how you could legally improve upon the Revenue Service's work. And I made some silly statement about, well, deterrence doesn't really make much difference here. And this old salty special agent in the Revenue Service said, well, in Detroit last year, that's quite a while ago, we convicted 2 doctors of cheating on their income tax. And it got a lot of publicity in the newspaper. And the next year, we collected $20 million more from the doctors of Detroit than we had the year before. There's deterrence. And deterrence is what judges are thinking about and what the system thinks about when probation officers and other people support that sentencing system. It's a part of the purpose of courts. Now, the next purpose the judges and administrators came up with was to rehabilitate persons convicted of crimes. Well, some places they put another deterrence label on that. They call that special deterrence because it's about the person in front of you. But rehabilitation is so much more complex than that. You need to look as a judge or probation officer or anybody else working in the system at all the possibilities. You say, well, what's the advantage of sending this person to prison? They'll probably come out a much better criminal. Best school for criminals there is. So that's really not our best option for anybody. Then they look at somebody who's never been involved in criminal behavior and they say, well, that's a plus on the side of we can rehabilitate them. Then they study rehabilitation. I'm talking about as a purpose of courts. And they find out that, and a very important fact about time, discovered that if you get people into a rehabilitative program quickly, there's a much lower rate of recidivism than if you take 3 months or 6 months or a year to get them in that program. We know that, established clearly. So again, when you're thinking about this, time, like in the other places, becomes a measure of whether you're likely to succeed. Well, we take another step. We say, what do you do when you don't know what to do with somebody who looks like they're going to be in a life of crime? Well, you warehouse them. And that leads to the 8th purpose of courts. The 8th purpose is to separate persons convicted of crime from society. We do warehouse them. Do they commit fewer crimes? No, as a matter of fact, they probably increases the criminal nature of our society because they commit the crimes in jail just as well as they did on the outside. We haven't reduced crime, but we've protected society, which you could say is one of those purposes that we should add to the whole list. Now, any one of you could probably say there are other dimensions to each one of these purposes. But when you're planning a courthouse, or planning for the operations of a court, or asking for a budget,
the judge is in the unique position to be able to lead this process, not just to making the change, but then thereafter in making sure that the lawyers do what they say they're going to do when they say they're going to do it, that the case management conferences don't become just a repetitive continuance, that lawyers, when they walk in with excuses why they didn't do what they say they were going to do, then the judge says, why not? There is accountability there. The judges are the ones that are in the central position of leadership to say to the lawyer, counsel, all right, you have an excuse, you have an explanation why you didn't get it done. How long is it going to take you to get it done? Can you get it done this week? I'm going to set it next Monday. Can you get it done then? Because next Monday I want you in here and I want this done. Because that's the thing that's holding the case resolution up.
When we discuss this with judges, very often they say, this sounds great, but I really can't impose sanctions in a criminal case. I don't have any power. How do we respond to that? And I think what you're pointing out is that the lawyers want to do what the judge wants them to do, and by setting up your system, you've encouraged them to do the right thing.
The most effective tool in that is for the judge to just simply say to the lawyer, counsel, I'm really disappointed. You said you'd do this. I'm disappointed. The system doesn't work if you don't say if you don't do what you say you're going to do. And that's been very, very effective. So the judges are key in getting the system changed, but they need everybody else. but the judges are also key in making sure that the system keeps functioning.
So you work your way through the process of designing the change, and we know it really is a process. Change is a process, not an event. It doesn't happen overnight. Could you describe for us in some detail the operation of the new system that you ultimately designed, and in particular highlight ways in which it departed from past practices?
Every Monday we would have what we called a cattle call, and we would call every case out there, and it was a waste of time. The consultant told us it was a waste of time. We went, oh, you know, she's right. Nothing gets accomplished. We don't do anything. We just do the cattle call.
And not only that, all the judges attended the cattle call, right?
Absolutely. It was a waste of all the lawyers had to be there too. We took to heart what the consultant said, and that is, don't have hearings unless they're going to accomplish something, and make every hearing accomplish something. In the old days, a case would come in the door, we would have an arraignment, we would set a trial date a year down the road. Nothing happened until the lawyers would file a motion, which generally wasn't until 30 days before trial or even a week before trial. Everybody would scramble around that week before trial, and oops, we've misplaced a witness. We can't find a witness. Or we need some evidentiary issues resolved, whatever it was. Nobody was ever ready on that first trial date setting. It was educational for me as a judge to find out, I don't want to call them excuses, but the reasons that the lawyers were giving as to why that case was more than 6 months old. Oh, well, we're waiting for a lab report, or this witness is on vacation, and oh, well, we forgot to call him, you know, when they were on when they got back. The reasons were just stunning in their simplicity in most cases. So the first trial date setting became a fiction. We said it, but everybody knew it wasn't going to go.
And it was a year out.
It was a year out.
And they still weren't ready.
And they still weren't ready.
Okay. So as the process continued, you and the other judges started to see that there were a substantial number of cases that probably could be disposed of at a much earlier time than they had been in the past. Am I right?
That's what I'm saying. Once I saw that, then I said, that's what we need to do. We need to start addressing these little excuses why a case needs to be continued. We can do that, and if we can do that, we then reduce the number of total hearings that we're having if we get rid of those easier cases earlier in the system. Now what happens is, at the arraignment, the prosecution gives to the defense disclosure. Never used to happen before at the arraignment. At the arraignment, we set a first case management conference 21 days out, 3 weeks out. During that time period, the defense is to give to the prosecutor mitigation. The prosecutor is to give to the defense a plea agreement. Usually at the first case management conference, 3 weeks out, they get up and they report to the court, yeah, we've disclosed everything, yeah, we've got the mitigation. We're talking about a plea, we need a little more time there's some supplement to the mitigation, we need some hospital records or a lab test or an interview or something like that. So then we set a second CMC, another generally 2 to 3 weeks out. So depending on the type of case, we might put it out a month out. But at that second CMC, at the latest the third CMC, we're starting to talk about why hasn't the case been resolved. The judge in doing the case management conferences is prodding the attorneys every single time. What can we do to resolve the case? Okay, you did what you said you were going to do. The judge writes a note in the file and says, I'm setting this for another case management conference, and you're going to get the witness interviews done, you're going to get the full exchange of mitigation, and the plea offer will be made. Is that correct, counsel? Yes, that's correct, judge. And this is the time you're both available, correct? Yes, it's the time we're both available.
What about the judge's involvement in settlement discussions?
The judges, especially in criminal cases, will inquire as to what progress has been made towards arriving at a plea. We've developed a rather unique process in our county where I'm a retired judge, and what they do with me is they set the settlement conferences with me because I'm not the trial judge. I can meet with the defendants individually and their lawyers, and more importantly, we shield the trial judge from anything that's said by anybody during the settlement conference. So before we set a case now for trial, we set up a comprehensive pretrial conference, which is bring your calendars, we're going to set a firm date. But I'm settling about 97% of the cases that come before me to do settlement conferences before the comprehensive pretrial conference. The pitch that I always tell judges is a comprehensive pretrial conference is set for 15 minutes. A trial is set for 3 or 4 days. If you have to bump the comprehensive pretrial conference, you've lost 15 minutes. If you've set that case for trial, you've cleared your calendar for trial, but we get the case settled, you've lost 2 or 3 days, idle time. So essentially what we're doing is we're managing the events that get cases resolved rather than just simply managing the time over and over.
Tell me a little bit about any problems you may have encountered in the implementation process.
And this old notion about they're rushing justice, that's a red herring. They're not. It has been said over and over again, by the time a case gets filed, within a matter of weeks, the prosecutor and the defense attorney, they know where that case is going to go, except in the, the extreme murders and that sort of thing. Most of them are drug cases, property crimes, DUIs, ag DUIs, things like that. They know what's going to happen on the case. And they have realized, the attorneys have realized, the sooner they get rid of those easy cases, they get them out of the system, the fewer hearings they're going to have and the more time they're going to have. And is anybody faulted or hurt by that? Absolutely not. The victims get their restitution quicker. The defendant starts getting needed treatment better and faster. The public is protected quicker. There simply is no downside. And the assurances that we gave the defense attorneys was, number one, that they were going to be an active part of this process, that we would not be jamming things down their throat. But number two, we kept asking them over and over and over again, especially when they went through that backlog reduction process too, why can't we do this earlier? But if we get rid of those easy cases earlier, then you're saving so much more time. And we get the same result, but we just get it earlier. And for them, the carrot is that you're going to be more efficient. You're going to be able to get more done. And then it'll give you time to work on those cases that you don't have time for now that really need lots of interviews and lots of hand-holding by your client or with your client or witness interviews or whatever it's going to take, research. You have actually more time to get that work done. I think the majority of the lawyers liked it because it gave them that predictability.
Well, it sounds to me like a case could be made that the system you've implemented, which reduces delay, results in achieving not only the same just result, but possibly a more just result as a result of the better use of time and the earlier application of the techniques that you've described.
Well, and as everybody knows, time diminishes memory. Police officers leave, investigators leave, witnesses forget, and with every bit of that delay is built in that uncertainty of, are we really getting the right story here? Are we really getting the right result here? By getting to it as quickly as possible, we are seizing on it when everything is fresh. So I agree. It is not just faster justice. I think it's better justice. And you just can't argue with it. It really does work. It's not easy, but it does work.